Hi, my name is Dave Wolkowitz. I'm a divorce attorney in Illinois. I handle complex divorces and also uncontested divorces in Illinois. This video is going to answer one of the most common questions I get. It's, can I get divorced in Illinois? Let's get started. Okay, so I want to tell you up front that in Illinois, the requirement is that at least one of the spouses must have lived in Illinois continuously for at least 90 days preceding the filing of the petition for dissolution in the divorce case. The petition for dissolution is what opens the case. It's similar to what would be called a complaint in a different type of court case. The important thing to understand is that only one of the spouses has to be a resident of Illinois prior to filing the case. It doesn't matter which one. So for example, say one spouse lives in California and one lives in Illinois. The California spouse can actually file a divorce case in Illinois if the Illinois spouse has lived in Illinois continuously for at least 90 days at that point. Or, of course, the Illinois spouse can also file the case. I want to quickly touch upon what happens if one of the spouses is a member of the military. So a member of the armed forces can get divorced in Illinois if he or she is a resident of Illinois, if he or she is based in Illinois, or if his or her spouse is a resident of Illinois. So for example, if the member of the armed forces is a resident of Texas and the spouse lives in California, but the member of the armed forces is based, for example, at Great Lakes Naval Base in North Chicago, Illinois, then that person can get divorced in Illinois because he or she is based in the military at a base in Illinois. Illinois, and pretty much every state I know of, has a residency requirement, like I said before. One of the parties has to have lived in Illinois at least 90 days preceding the filing of the petition for dissolution that opens the divorce case. That's not really a very long time. The reason that's required is because states, legislatures essentially don't want divorce tourism. In other words, if there was no residency requirement, people would just file for divorce in any state trying to manipulate their divorce based on the laws of the state and which state they like better. There's another important point I want to make. It doesn't matter at all where you got married. So for example, if you got married in the state of New York and at least one of you meets the 90-day residency requirement in Illinois, you can get divorced in Illinois. So it doesn't matter at all where you got married. Let's switch that up a bit. So let's imagine that you got married in Illinois and now both people live in other states. They're residents of other states. Well, they don't meet the 90-day residency requirement. Therefore, they can't get divorced in Illinois, even though they got married in Illinois. Okay, so I hope I've answered the question, can I get divorced in Illinois? If you need more information, feel free to visit my website, uncontesteddivorceinillinois.com. I hope you know that uncontested divorce in Illinois is the fastest and most affordable way to get divorced in Illinois. If you have comments or questions, feel free to use the comment feature in this video. You can also check out the description for more information and very useful links. Thanks a lot and good luck.